The court has considered the factors that I already reviewed as the law requires. The court is also mindful of other circumstances in the case. I am also the judge who is in the Lawhorn neglect case, and I have extensive knowledge of the family from which Jamarian comes. He has been raised in a home with a lengthy history of neglect and physical abuse. His mother had her parental rights terminated over 2 previous children a number of years ago for physical abuse. Child Protective Services were involved with the family in August and September of 2005 and as recently as May and June of 2013. In 2013, Ms. Lawhorn and her longtime partner, Bernard Harold, were substantiated for physical abuse of Jamarian. He was beaten with an extension cord so brutally as to leave permanent scarring on his legs. Then he was moved to his father's home in New York, where he was beaten by his alcoholic paternal grandmother before being returned to Grand Rapids and his mother and Mr. Harold's home. And I must say that the court was not entirely persuaded by Ms. Lawhorn's or Mr. Harold's trial testimony that neither had used physical punishment on Jamarian since 2013. While no child should be subjected to neglect and physical abuse like Jamarian was, the court understands and appreciates that a troubled upbringing is neither a legal defense to murder nor an excuse for violent behavior. But Jamarian was 12 years old when he committed this killing, and it would be naive to conclude that his life experience had nothing to do with his scheme of killing someone so that he would be arrested and executed. The U.S. Supreme Court, Miller versus Alabama, which is sort of the most recent case that the court has decided, a case where a 14-year-old child from Alabama had killed someone. That's someone who was 2 years older than Jamarian at the time he committed this crime, explained in some detail the reason why we as a society treat juvenile killers differently than adult killers. The court relied on 3 significant gaps between juveniles and adults. First, children have a lack of maturity and an underdeveloped sense of responsibility, leading to recklessness, impulsivity, and heedless risk-taking. Second, children are more vulnerable to negative influences and outside pressures, including from their family and peers. They have limited control over their own environment and lack the ability to extricate themselves from horrific crime-producing settings. And third, a child's character is not as well formed as an adult's. His traits are less fixed and his actions less likely to be evidence of irretrievable depravity. The court further noted that as science has progressed, the science continues to show fundamental differences between juvenile and adult brains. For example, in parts of the brain involved in behavior control. There is a difference between a 12-year-old and an adult making a horrible decision like this. The case is a tragedy all the way around for any of us who have been involved in it. A 12-year-old child brutally murdered at random, a 9-year-old defenseless child, leaving behind a family that aches over the loss of a child deprived of the ability to grow up, to fall in love, and to make life choices for himself. And the 12-year-old killer who did not choose to be raised in an abusive and neglectful home is now faced with coming to terms with the pain he has inflicted, losing his freedom, and losing the ability to lead a normal childhood and adolescence. It is the court's decision to impose a blended sentence in this case. That is a disposition that delays the imposition of a prison of sentence under MCL 712.8.18(1)M. The court places Jamarian on probation under MCL 712.8.18 sub 1 sub B with appropriate conditions. Those conditions include being committed to the Muskegon River Youth Home under MCL 712.8.18(1) sub D. The court reserves and delays the imposition of a prison sentence unless and until a request is made to impose a sentence of imprisonment. As I understand The positions of the parties, both parties agree that it is appropriate to simply wait to determine an appropriate sentence if and when the court is asked to impose such a sentence. I do want to remind everyone, and I'll of course remind Jamarian at review hearings, that violations of probation under the law can result in the revocation of the probation and the imposition of the adult prison sentence. It is critical that Jamarian make his best efforts at the Muskegon River Youth Home to take advantage of the services, to abide by the rules, and to prove to all of us and to himself that he is capable of turning his life around. I believe in redemption. I'm not willing to give that up on a 13-year-old boy at this point. Jamarian, you have the right to appeal your conviction to the Michigan Court of Appeals. The court will appoint you an attorney if you cannot afford one. We are about to provide you with a form to request a court-appointed attorney. You must complete the form and return it to the court within 42 days, or your request will be denied. Ms. Retzkevich, I'd ask if you would kindly make sure that Jamarian completes the form now, so that we do not run any risk of him waiving his appellate rights. Following their meeting with Jamarian after today's hearing, the court will discharge both Mr. Bukalu and Ms. Retzkevich from their respective roles as defense counsel and guardian ad litem for Jamarian. It has been a difficult case. The court thanks each of them for their service under difficult circumstances. The court will simply appoint a new counsel from our assignment panel to handle the review hearings in the future. Ms. Seidel, is there anything else you would like to bring before the court while we're here?
No, Your Honor.
Mr. Bukalu?
Nothing else.
Ms. Retzkevich?
No, Your Honor.
Jamarian, good luck. I'll see you at review hearings in about 6 months. I wish you the very best of luck, and thank you all very much. Oh, well, would you just, yeah, okay.
Oh, I'm sorry.
I'm just going to make some copies and just.
I just don't want to run any risk getting waived.
And then I will bring you this right back.
We'll go.
Joy Racket.